Buckle up, guys. Today we are going to watch a man turn an HR problem into a courtroom drama. Mr. Scott explains he dated a coworker who now mocks him online, and he's sure it's a career-level threat. Instead of using HR, he's in front of a judge demanding protection from memes, trying to turn office gossip into legal danger. It's a snapshot of emotion colliding with the structure of the legal system. You can already feel how badly he wants the court to fix his pride.
It looks like you and Ms. Krusich either are or were in a relationship.
We dated. We don't live together. Never have lived together.
But you dated.
A little bit. Yes, Your Honor.
And both she and Ms. Gogan work at DSHS.
Correct, Your Honor.
Okay, as do you.
Yes, 30 years.
Okay. And are you in their supervisory chain of command?
Can I explain that to you, Your Honor? So, I work for the Office of the Secretary. Mrs. Gogan, she's administrative assistant for our boss, who is the second in command of the whole department. Lisa Yanagita is the chief of staff. Okay. So that's where where the problem lies, is that per our administrative policy that I think I attached there for you to look at, she's violated that. And as I move forward and present a lawsuit and everything else, because in this, in some of the photos I sent you, she sent these memes and information around to the office. And if you see the one that I sent you, where it says in there, do you see who's on there? And I'm a coworker. Where she says, dude, I wouldn't normally message a coworker, but I can't stop laughing. So here it is in this office where you're the admin assistant to the second highest person in our administration. And now how am I supposed to work with you every day and trust when you're discriminating and doing all these acts of inappropriate behavior in the workplace? Mm-hmm. And so part of my action is I'm probably going to file a lawsuit against her. And so I need that protection for me, because
here, Scott leans harder into the victim narrative. He reads captions, memes, and posts like criminal exhibits, insisting jokes about his dating life are discrimination and defamation. He stacks up his titles and achievements to show how important he is, hoping status will turn teasing into a legal crisis. It's less about safety and more about forcing respect through the court. From the outside, it looks like he's trying to litigate his hurt ego instead of any real threat.
Per our policy, this administrative policy, she's probably going to lose her job because of that. She even the words that she uses, where she knows what she's doing is right. I wouldn't normally message a coworker, but I can't stop laughing. And then even looking at this, she talks about how she's in this picture with her boyfriend, but she's on this single dating site just for kicks. And then the meme that she puts in there, where and she makes a comment and she's laughing her head off. That in itself, and then I'm the senior administrative officer there. I'm third from my boss in the department. I've been working for DSHS for 30 years, Your Honor. I've attained my MBA. I have a HRMS background. I have a Sigma SME.
In this segment, the judge quietly pulls things back to reality. She presses Scott on what he truly fears and what danger he's actually facing. His answers keep circling embarrassment, reputation, and office politics, not violence or stalking. It's the classic moment where emotional discomfort gets mistaken for legal wrongdoing, and the judge won't treat them as the same thing. You can feel her drawing a hard line between feelings and law.
I've been in the Army 20 years. Currently, I own my own business. All these things that she's doing affect me greatly. And it's an issue and it's a concern. And once that lawsuit drops, it's going to be a problem. So that's the Gogan thing. And then if you look at the administrative policy on number 3, actions that violate this policy aren't limited. violations via phone, email, text, social media, electronic communication. Um, Such behavior can also be outside of work. Um, it specifically speaks to this in our administrative policy.
So as to Ms. Gogan, your concern is about her posting something online.
Well, in the workplace. So,
okay, and what about Ms.
So let me finish this, please. Let me finish this. So I also have currently the Washington State Attorney General's office. I have a motion in with them because these folks are up. There are putting photos online without the permission of
Who's doing it?
Are we dating him too? It's a site that's it's a group that's embedded into Facebook. And currently I have with this attorney generals to take that website down because they are putting males photos up without their permission.
Now the story shifts from hurt feelings to supposed life fallout. Scott insists these posts could cost him military respect, a board seat, and his standing in the community. He uses every title he holds like armor against mockery, as if status should block criticism. The stakes are real for his image, but the judge is listening for unlawful conduct, not just social embarrassment. That difference between reputation damage and legal harm is the wall he keeps running into.
And there are women who are on there that are anonymous, so you don't know who it is. It could be any bandwagon person like Ms. Gogan, who's in a dating relationship, who jumps on there for giggles and can post anything she wants. There's not, it's libel and it's slanderous. And here I work with this person, and you're going onto a website like that where it's very, very libel and slander. So I'm working on doing that for that website. Mrs. Krusich, she was upset that I stopped dating her, and I sent her home one night. And then here, when you're looking at a couple of those, her first posting, she tried to be anonymous and said that this guy was trying to get me to go to work or to blah blah blah, and I sent the photos on there. It didn't look like I tried too hard to get her there. She looked pretty happy there. And then currently, not only does she work for DSHS, but she also has a few things of mine, and she's saying things that are disparaging on that website. And now she has her name on there, and she's identified me where I work, which is very slanderous. I'm currently in my position. I'm in the Army Reserves. I'm also a voting member for BHR in Olympia. And she knows several of those folks. So here it is, you're saying slanderous and libel things, and I could lose that spot, which is a very coveted position for me to be on a voting board here in Olympia.
This is where the judge draws the constitutional line. She explains that online name-calling, even when it's unfair or cruel, is protected speech, and protection orders are not censorship tools. She separates workplace rules from courtroom power and tells him plainly the court can't silence critics. Viewers see that a hurt reputation and illegal conduct are not the same thing. It's a cold reminder that the Constitution protects speech long after it stops feeling respectful or kind.
Because one of the things we don't do with the protection order process is keep people from saying bad things about other people. It's their First Amendment right. And so I get this all the time from people who say, you wouldn't believe what they say about me. None of it's true. And they post it on social media. They broadcast it to the world. They call me a pedophile. They call me this. They call me that. And we say, sorry, we can't do anything about that.
I agree with that, Your Honor.
So I don't know how I can do something about this.
For me, it's work. I have to.
Right. But that's
Ms. Goldman can't come.
No, I understand your position. This is, you don't like it, and things should happen at work because she's violating work policy and so on and so forth.
So what if something happens, Your Honor?
Well, we can't do something proactively here. We can only do something if it meets the statutory requirements. So if she gets fired because you complain about her, whatever she posts about you, and she gets fired because she's violating the DSHS policy, which sounds like that potentially could happen. Then if she starts calling you and threatening you, then we can give you a protection order. But right now, you're just saying she's going online and telling the world that you are whatever she is, she's laughing at you or whatever she's doing. And the same for Ms. Krusich. I don't know if I'm
that's
pronouncing
correct.
it. Yeah. And same for Ms. Krusich. They have the ability to do and say that. I can't tell them to stop. DSHS can. They can say you're violating our agency policy, and for doing so, here's the sanction, whether it's whatever it is, firing or loss of pay, or give up your computer or whatever.
Right.
They can deal with that. I can't. This is not the appropriate.
Here we see the emotional come down. The judge formally denies his request and repeats that this process can't fix nasty office culture or bruised reputations. Scott admits he's trying to exhaust every option, then broadens it into a larger struggle he believes black men face on these sites. The case ends on frustration, showing that unfair doesn't always mean unlawful. It's a moment where the audience can sympathize with his feelings, but still see why the judge's hands are tied.
Procedure. You can file civil lawsuits against them for the damage
that's coming. Yeah,
that's you feel has been caused to you, and your harm of your reputation and those things. Those are actionable potentially with a lawsuit, but this process isn't meant to address that. So you're not going to get any what we would call a remedy out of this. I can't give you anything that will address it. So, so I'm just going to enter denial orders on these and not send them for a hearing. For that reason, I'm not, and I want to be clear. I'm not saying that what you're having to deal with is too small for this or anything. It's just this is not the appropriate process for that.
Oh, that's fair. For me, it's about exhausting all my means.
Yeah.
So
no,
it's not an end all for me. It's just another bullet in the process for me.
Yep, I get it. Certainly be frustrating to have a situation like that.
No, the frustrating part is that there are other males that I know that are black males that are like me that have been dealing with this on these websites, and that's I'm not sure. I think there's a point in there where Washington State is a two-party consent state. I just haven't dug it deep enough, but I believe I've seen that in there.
We switch to Florida, where a new defendant gets one of the sweetest offers in criminal court: pre-trial intervention. The judge calmly explains that if he follows simple conditions, the state will drop all charges and wipe the slate clean. His public defender has already done the hard work. From the outside, you can feel viewers wanting to shout not to overthink this deal. It's a rare moment where the system is practically begging someone to win if they'll just say yes.
Enjoy it.
On the morning docket, you had continued Kareem Williams from, I believe it was last week, the out of custody pretrial, because he wasn't able to get to Panama City.
Okay. Come on up, Mr. Williams. Okay.
Judge, he had been offered a pretrial intervention. We had supplied that to him, and I'm not sure what his intentions are. All right.
You understand a pretrial intervention is an agreement you have with the state that's basically supervised by the probation and parole, and then the case is dismissed if you successfully complete that term.
Could you repeat it?
Pretrial intervention is a program that's offered by the state, and it's supervised by the Florida Department of Corrections. It's like probation, but it's not probation. It's an agreement that if you successfully complete the pretrial intervention, the state drops the charges against you.
I spoke with my public defender, and he gave me the terms and the things that I have to do, and I didn't agree with him.
Okay.
And I don't understand.
Sir?
I don't understand. So, like, the charges would be dropped.
If you
did all those terms,
you have to abide by those terms and conditions, and the case would be dropped.
Could I ask a couple questions?
The sovereign citizen mindset kicks in here. Instead of asking if the offer is smart, he challenges who the injured party is and whether the state has any jurisdiction. The judge shuts that down, explaining only the state brings charges, not victims. While he chases pseudo-legal theories, he's walking away from a near-guaranteed dismissal that most people would beg for. For viewers, it's a textbook case of pride and bad legal advice rolled into one dangerous mindset.
Yeah, I mean, I spoke with him shortly. I didn't really get all I really spoke over, all we went over was the terms.
We had several phone conferences that were scheduled.
Yeah, we missed a lot due to the time difference.
Sir?
I said, but we missed a lot due to the time difference.
He was on Eastern time and he would call an hour late.
I mean, a pretrial intervention is about as good as it gets. If you can take it or not take it, are we ready to set it for trial?
Yes, sir.
I don't want to do trial.
In this brief but telling stretch, the judge stops trying to sell the deal and flips into trial mode. Dates are set, expectations are clear, and the window for an easy exit quietly closes. The room shifts from opportunity to consequence. By the time he realizes what he passed on, that lifeline will be gone and he'll be gambling with a jury instead of a clean slate. It's a perfect example of how a few stubborn minutes in court can completely change the trajectory of a case.
Well, then Mr. Meredith has done exactly what he's supposed to do for you. He's got the very best deal worked out for you. If you abide by the terms and conditions of the pretrial intervention, the state will dismiss the charges.
So the charges are brought upon me are by the state.
Well, who do you think brought them?
I thought I had a party.
Huh?
I thought it was an injured party.
The injured party, aren't they dope cases?
What is the jurisdiction of it? Is it criminal or
I
civil?
don't think you're near as smart as you think you are. I can
I'm just
tell,
asking
I can
questions.
tell you're not. Your possession of a controlled substance, giving false name, causing adverse effect. I guess there could be a victim on that. And resisting officer without violence. So, I don't know anything about the case, but it looks like you might have got a false, gave somebody else's name.
You just told me that the state was the.
The state's the only person who can charge you. Nobody else can charge you. It's the
Oh.
state. The victims can't charge you. They're just the alleged victims. They can't charge you. They can't do anything except make a complaint. But you've got to offer a pretrial intervention. If you do the pretrial intervention, the state will drop the charges against you. If you don't meet the pretrial intervention, you come back to court and you start your defense again.
I don't wish to argue the facts.
So let's set it for trial.
Yes, sir.
Let's set it for May 5th at 8. Let's set it for June. What was that June date?
June 2nd.
June 2nd at 8:30. And it will be May 23rd
Yes, sir.
at 1:30 for trial management.
Finally, we meet Jennifer, arguing to undo a default judgment after ignoring the case until her wages got hit. She leans on personal hardships and demands debt validation, but the judge focuses on two simple tests: good cause and a real defense. He finds neither, keeps the judgment in place, and reminds everyone that courts run on evidence, not vibes. If you enjoyed this breakdown, make sure to like the video and subscribe to the channel, and we'll see you in the next video.